Good afternoon. My name is Michael Brown, and I'm the Executive Director of the International Law Students Association. On behalf of the International Law Students Association, myself, our Board of Directors, chaired by David Shepper, our outgoing student officers, President Meredith Clapp, Vice President Kelly Thomas, and Chief Communications Officer Andrea King, and our newly elected student officers for the 2006-2007 year, Vernon Johnson, David Schaefer, and Amanda Burkett. I welcome you to the Sherman and Sterling World Championship round of the 2006 Sherman and Sterling International rounds of the Philip C. Jessup International Law and Court Competition. We have two excellent teams here arguing the final round. They are a product of rounds that began back in February and memorials back in January. In a sense, every single one of you who has participated has contributed to the success of these two teams, because not only have they done splendid work in preparing their own memorials and in preparing their own oral arguments, but they have learned from each and every one of the teams they have faced, starting in the regionals and nationals, here at the international rounds, and especially in the advanced rounds. And each of you who faced them have in turn learned from everyone you've faced, so that ultimately this final round is a testament to every one of the 565 teams all over the world, from Kazakhstan to Vancouver, who have put pen to paper and written a memorial or stood up at a podium and argued in front of a judge. So I would like, before we begin and before we applaud them for all their hard work, for you to please applaud yourselves and each other for a wonderful year. To my right, to your left, we have the team from team number 187, which, so as not to let any sound go into the back room, I will simply refer to as team 187. Arguing first is Federica Padu, second, Mariana Clemente, and of counsel, Adela Troconis. Other members of the team, Carlos Maduro, Daniela Blanc, and their coaches, Ricardo Chirinos and Ana Cristina Nunez. Arguing to my left, to your right, the team I will refer to as Team 849. Arguing first, Vincent Levy. Second, Tracy Appleton. And of counsel, Seth Davis. Also on the team, Alka Pradhan and Corey Whiting. Our judges, beginning with, I believe seated at the President's left, the former legal advisor to the United Kingdom Foreign Commonwealth Office, Sir Michael Wood. Second associate, the legal advisor to the Organization for Economic Cooperation and Development, Nicola Bonucci. And the president of this year's 2006 Sherman and Sterling Championship round, from the International Court of Justice, His Excellency Bruno, Simma. In a moment, the bailiff will call all rise, and we will stand and will naturally begin. Promptly at the conclusion of the round, I shall announce the winners of the memorials and moral awards from the preliminary rounds, and then the judges will return and announce the results of the round. Because two of our judges are on very tight timelines, we will distribute additional awards, specifically the awards we give out to the teams that advanced to the advanced rounds at tonight's closing gala back at the Fairmont. With that, I will turn it over to the oralists and to the judges. I wish you all the best of luck, and I wish us all perhaps a cooling breeze off the river. Thank you.
The International Court of Justice is now in session. The distinguished panel consists of President Simma and the Honorable Judges Bonucci and Wood.
Please be seated.
As you're all aware at this point, the case before the court is the matter of the Republic of Acasis versus the state of Rubria. The applicant and respondent teams are each allocated 45 minutes to present their respective pleadings, and good luck to both sides.
So I give the floor to the applicant. Council may go ahead.
May it please this honorable court. Good afternoon, Mr. President, Your Excellencies. My name is Federica Padeu, and I am an agent on behalf of the Republic of Acastos. My co-agent is Mariana Clemente, and sitting as counsel, Adela Troconis. Today, I will be addressing this court for the next 21 minutes in order to deal with the first and second issues of the compromise, arguing that the court has jurisdiction over all claims in this case, and that Rubria, by permitting the construction of the pipeline, has breached rights of the Elysians. My co-agent will then address this court for the following 21 minutes in order to deal with the third and fourth issues of the compromise, arguing that the acts of fraud are attributable to Rubria and constitute violations of international law, and that Acastos has not breached Article 52 of the Rabbit. Each of us will be dealing with our own remedies, and we will reserve 3 minutes for rebuttal. If it pleases the court, I shall proceed. Your Excellencies, turning to the jurisdiction of the court. In the present case, the jurisdiction of the court is based on 2 different grounds. First, on Article 62 of the Rabbit, for those matters falling under said treaty, and to which both the applicant and the respondent state have consented. And second, on the compulsory jurisdiction declarations filed by the state of Rubria and by the state of Nessus, to which Acastos is a continuing state. The jurisdiction of the court on the optional clause declaration is based on 3 different contentions. First, that Acastos continues the international personality of Nessus, and therefore has maintained in force the compulsory jurisdiction declaration. Second, because Resolution 2386 is not a bar to its membership in the UN as a continuator state. And third, because in the alternative, the Legal Council has allowed Acastos to maintain a sui generis membership vis-à-vis the United Nations. Your Excellencies, turning to the continuity of the state of Acastos vis-à-vis Nessus. The United Nations Sixth Committee of the General Assembly in 1946 indicated that by the mere fact of certain constitutional or territorial changes in a member state, the state does not cease to be such a member of the organization.
Council, if I could interrupt you, and I apologize for interrupting so soon, but I'm rather puzzled by your request for relief. In paragraph 37A of the compromise, you ask the court, you say that the court has jurisdiction since Acastos has succeeded to Nessus' status as a party to the statute. But here you're talking about continuity. Could you explain how it is, or what relevance we should attach to the word succeeded in your claim for relief?
Your Excellency, there are certain scholars that consider that continuation and succession to UN membership must be treated equally, which would include, for instance, Sharf. However, from the facts of the compromise, there is evidence that the intention of Acastos was to continue the membership of the former Nessus in the United Nations. This may be evidence, for instance, from paragraph 8 of the compromise, where Acastos sent a diplomatic note to the United Nations Secretary General, stating that it would continue the membership of Nessus in the United Nations, as well as all the relevant treaties that were in force with respect to Nessus.
Well, I do understand that that's your position, but why then did you, in the relief, refer to yourself as a successor state?
Your Excellency, because it isn't clear whether or not Acastos continues the international personality of Nessus, and therefore Acastos is present before this court in order to request the court to determine that it is indeed such a continuator state. And this, Your Excellencies, may be done through the various elements that have been suggested by scholars that may establish when or not a state continues to exist. Scholars such as Sharf, Lloyd, Buehler, and Mullerson have indicated that continuator states must retain certain elements of identity with the previous state. These elements have commonly been divided into objective and subjective elements.
Council, if I could ask again, or interrupt again, it's a difficult issue, and you're trying to expound to us the rules of international law governing continuity of states. You've referred this to scholars. What weight should we attach to those as opposed to state practice or court decisions or other sources of international law?
Your Excellency, if I may answer your question in different steps. Firstly, with respect to state practice, the opinions of scholars may only qualify as subsidiary means for the determination of rules of law, according to Article 38(1)d of this court statute, whereas state practice is an element of customary international law, as indicated in Article 38(1)b. As to the weight of the opinions of scholars with respect to decisions or judicial decisions, the weight is the same, since both are referred to as subsidiary means for determination of rules of law. In the present case, Your Excellencies, the applicant state is merely submitting the teachings of scholars as suggesting the existence of certain elements that were present in previous cases of state continuity. Your Excellencies, these elements are commonly divided into objective and subjective, and the majority of scholars, including Crawford, Marek, Fiedler, Schloch, and Shaw, consider that when the objective elements are doubtful, the decisive element is the subjective element. This
Counsel, again, you are focusing very much on writers, some of them less well known than others. So why don't you focus on the primary sources or the principal sources in 38(1), A, B, and C, instead of following this scholastic method of enumerating, like Grotius, all these writers?
Your Excellency, because in issues of state continuity, there are no treaties that regulate the matters, as evidenced from scholars such as Ortega. The only treaties that exist are those concerning the succession of states, which principally do not codify customary international law, but they evidence progressive development of international law. Of these treaties, only one is nowadays
They really evidence a progressive development of international law?
I'm sorry, could you rephrase
They
that?
really, the treaties you referred to are probably the Vienna Conventions, right?
The Vienna Conventions and
That
successions.
they embody a progressive development of international law.
Yes,
Why
sir.
has that development found so little, let's say, acceptance by states if it is so progressive?
Could you please rephrase? I couldn't hear the question.
I'm sorry. Why have these conventions found so little acceptance by states?
Very few states have ratified the Vienna Convention on the Succession of States because they believe that these, in fact, should regulate the matters dealing with state succession. However, these Vienna Conventions have not been generally ratified. But in any case, Your Excellencies, the applicant state submission is not one of succession, it's one of continuity. And given that there are no rules of conventional international law or general international law that could regulate matters dealing with state continuity, one must look into the state practice and the commentaries given of this state practice by scholars. The state practice within the context of the United Nations are those cases of India, Yugoslavia, and the USSR. Each of these cases was clearly different from one another, and Acastus is not claiming that any of these cases is identical to the case of Acastus. But as the United Nations Sixth Committee of the General Assembly indicated in 1946, each case of continuity, Your Excellencies, must be assessed in its own merits. Your Excellencies, in the present case, there is evidence that Acastus perceives itself as the continuator state of Nessus, as evidenced from the fact that it has issued a note to the United Nations Secretary General indicated that it intended to continue the previous state's personality. But moreover, Your Excellencies, there has been acceptance by the international community to this claim of continuity. In fact, after the notification was sent, the issuance of Resolution 2386, the General Assembly...
Sorry, Counsel.
Certainly.
You're mentioning Resolution 2386, and if I read paragraph 9 of the compromise, it says that considering that it is unclear whether Acastus and Orubia should probably be deemed to the successor state of Nessus. So, yes, you had a claim of continuity, but even the Resolution 2386 it doesn't speak in terms of continuity, it speaks in terms of successor.
Yes, Your Excellency, I understand your concern. However, precisely because it is not clear which one of the two should properly be deemed the continuator, the resolution might have referred to succession. And in any case, these are only considerations of the Security Council, but they do not embody the, in fact, decisive element of the Security Council, which is the resolution issued. In that particular case...
Could I ask Counsel whether It's yours whether you accept that this was a valid resolution of the Security Council. Was it within its powers to pass a resolution in these terms?
Yes, Your Excellency, we accept the validity of the resolutions because in fact the United Nations Security Council, under the Charter, has powers of recommendation in the issues dealing with membership, as established in Articles 4, 5, and 6.
So this is a recommendation, is it, this resolution?
Yes, Your Excellency, it is the applicant state's submission that in this particular case, Resolution 2386 is merely a recommendation. In fact, the decisions of the Security Council may not be presumed to have binding force, as indicated by Ameda Singhe. And as indicated by this court in the Namibia case, Security Council resolutions may only be binding when issued under Chapter 7 of the United Nations Charter or under the general implied powers of the Security Council for the maintenance of international peace and security.
I wonder, Council, could you turn to the actual language of the resolution, which is in paragraph 9 of the compromise, and point to what you think the key words are?
I'm sorry, could you please, I couldn't hear the question, Your
Sorry,
Excellency.
if you could take us to the actual language of the resolution and explain what you see as the key words in that resolution for your case. Thank you.
Your Excellencies, the resolution decided that Augustus should apply for membership. And if the Security Council has powers of in respect of membership issues, the general procedure established for membership should be followed, as in the case of Yugoslavia, and as was argued by the representatives of Britain and France, and as indicated by several scholars, including Your Excellency Wood. In this particular case, Your Excellencies, this is a mere recommendation under general implied powers of the Security Council, and therefore cannot constitute a bar for Augustus's membership in the United Nations as a continuator state. And in particular, Your Excellencies, the General Assembly has acquiesced to this presence. The nameplate of Augustus remains within the General Assembly. Augustus continues to pay the membership dues of Nessus, but most importantly, the flag of Augustus is flown at all UN buildings. May we refer Your Excellencies to the fact that according to the Office of External Relations of the United Nations, only member states can have their flag flown at the UN buildings. And in this particular case, Your Excellencies, the flag of Augustus is the first flag to be flown at all UN buildings. Therefore, this is sufficient to establish that the United Nations has acquiesced to Augustus's presence as a continuator state, which would entail that Augustus has maintained the compulsory jurisdiction declaration, giving therefore jurisdiction to this court to entertain the merits of the case. Your Excellencies.
Council, given the time, you'll probably want to move on to question 2, but I had one last question about jurisdiction. In the alternative, your argument is that if this court finds that you are not a party to the statute, then the court should also find that it has no jurisdiction under the rabbit issue.
Yes,
Could you explain why that is so, given that you expressly agreed to the jurisdiction of the court in the rabbit agreement?
Your Excellency, that is because of the interpretation given by this court in the legality of use of force cases in the year of 2004. In that case, the court established that for a non-party state to the ICJ statute to have access to the court based on a compromissory clause, such as that of Article 62 of the rabbit, the treaty containing the compromissory clause should have been signed before 1945, that is, prior to the entry into force of the ICJ statute. In the present case...
You said it should have been signed?
Ratified, I'm sorry, entered into force. I'm sorry, Your Excellency. In this particular case, the rabbit was ratified before the decision of the court in 2004. It was ratified in 2003, and therefore there was no foreseeability of this decision given by the court.
Excuse me, did you say ratified? Is that correct? Is that the critical date? Because one country might have ratified it 20 years before the other. So
Yes.
What do you think is the critical date?
According to Your Excellencies, to the compromise, the rabbit entered into force on April of 2003. Your Excellencies, therefore, if this court finds that Augustus is not a party to the ICJ statute, the court would like jurisdiction to entertain the claims under the rabbit. Now, Your Excellencies, moving to our second...
Sorry.
Yes.
I noticed that this argument was not raised in the memorials. You're raising it now. So I have two questions. First, do you think that you're allowed to raise an argument which has not been raised in your written proceedings in front of the court? And if the answer is yes, what is the rationale for raising this additional argument which was not in the memorial?
Your Excellency, if I may defer, this issue was argued also in our written submissions within the content of the jurisdiction part. Your Excellency, proceeding to the merits of the case, at present, Rubria has permitted the construction of a pipeline over the Elysian, a territory that was inhabited since prehistory by the Elysians, and particularly those lands located in Rubria were used by the Elysians for their agricultural survival since well before the Industrial Revolution. Your Excellencies, even if the applicant state does not dispute that Rubria has territorial sovereignty over these lands and has permanent sovereignty over its natural resources, these rights are not absolute, and the limits are precisely human rights, which are the ones that have been breached by the permission of the construction of the pipeline.
Excuse me, Counsel. Could you point us to some documents or legal texts which make the use of a state's territory dependent on observance of human rights?
Yes, Your Excellency. Firstly, the International Covenant on Civil and Political Rights, and second, this court's case.
Can you indicate where and how the covenant makes that point?
Yes, Your Excellency, it is established in Article 2 that all states must respect human rights within their territory, without any to all individuals within that territory, without any discrimination.
Has there been any practice of the application of the point you want to make that reference was made to Article 2 of the Covenant in an environmental matter?
No, Your Excellency, but if we may defer, this is not a case dealing with environmental issues. In fact, as indicated in the clarification, all of the damages, environmental damages that could be caused would be within the territory of Rubria. And this is not the applicant state submission. What the applicant state contends is that by permitting the construction of this pipeline, Rubria has violated the rights of the Elysians to protect their culture. And this is a right that has been enshrined in Article 27 of the International Covenant on Human and Political Rights. Now, the respondent may argue that...
I'm sorry, if I remember correctly, Article 27 speaks of members of, individual members of a minority. So can you apply just like that to, and read it in the sense of group rights, which you apparently do?
Yes, Your Excellency. According to General Comment 23 of the Human Rights Committee, interpreting the content of Article 27 of the ICCPR, this right entails all individuals within a state's territory, not only the nationals or citizens or permanent residents of the state, but also every person that travels within the territory, such as, for instance, migrant workers or even mere visitors within the state's territory. In the present case, Your Excellencies, the Elysians, a minority because they are an indigenous population, were present within Rubria, And by permitting the construction of this pipeline, Rubria would be violating their right to protect their culture. In fact, precisely...
Do you find it in Article 27? Could you indicate some other provisions of international human rights treaties where the right to culture is protected?
No, Your Excellency. However, the Human Rights Committee has indicated that this right...
Have you ever heard of the Covenant on Economic, Social and Cultural Rights?
Oh, yes, Your Excellency, I'm sorry.
Do you know how that covenant is being monitored?
I'm sorry?
Do you know how the Covenant on Economic, Social and Cultural Rights is, how performance is being supervised?
No, Your Excellency.
Because you might have found some materials relevant in the work of the Committee on Economic Rights, of which the president of the ICJ was a member.
Thank you.
It's so neglected that I wanted to...
Okay, I will read that as I go home. Now, Your Excellencies, with respect to the Article 27 of the ICCPR, the Human Rights Committee has indicated that for indigenous populations, the right to...
Before you continue with that, what weight, if any, should we give to these comments of the Human Rights Committee? What value do they have as such? With apologies to the President.
Your Excellencies, given that the members of the Human Rights Committee are experts in the matters dealing with human rights, they must be considered as teachings of highly qualified scholars therefore falling under Article 38(1)(d) of this court's statute. Your Excellencies, in this case of the Human Rights Committee and commentaries, the Human Rights Committee has indicated that indigenous populations have a particular tie to their land, and therefore the agricultural activities that they carry out within these lands must be considered an essential element of their identity. And by permitting the construction of the pipeline, Your Excellencies, it is an agreed fact in paragraph 21 of the compromise that these lands...
Is the title of these people to land being affected by the pipeline? You said that they have a title. The title remains intact as far as I can see.
No, Your Excellency, I'm sorry if I didn't express myself clearly. The ties of these indigenous populations to the land will be affected because it is an agreed fact in paragraph 21 of the compromise that half of the agricultural lands will be destroyed and that the remaining half agricultural yield will be greatly damaged. Therefore, Your Excellencies...
Counsel, sorry. But this statement that the rights of the Elysian people, if there are rights, will be affected is based on a single study made by an NGO called ILSA. Do you think that the court should be satisfied by a single study made by an NGO, in particular when we see that, as in the statement of facts or in the compromise, there was a private conversation between, paragraph 25, a private conversation between the ILSA study team and Mrs. Galatea, who was the representative of Elysian. So do you think it's a sufficient undisputed basis for reaching the conclusion that you are reaching? If not, do you think it is in the power of this court to order new studies or even to proceed to an on-site visit?
Your Excellencies, if I may answer your question. With respect to the NGO report, Your Excellencies, this court referred in the Congo versus Uganda case that respectable NGO reports must be considered, must be given certain weight in the decision of the court. However, the applicant state is not relying on the ILSA report, but on the agreed fact established on paragraph 21 of the compromise that these lands will be that half of these lands will be destroyed and the remaining half will be greatly damaged. May it please the court.
The sign apparently means that your time is up, and I give the floor to...
May it please the court.
Yes.
May it please this honorable court. Good afternoon, Mr. President, Your Excellencies. My name is Mariana Clemente, and I am an agent on behalf of the Republic of Acastas. As my co-agent already indicated, I'll be addressing this court for the following 21 minutes with respect to the third and fourth issue of the compromise, dealing first with the attribution to Rubria of PROS actions and their international unlawfulness, and second, with Acastas' alleged breach of Article 52 of the Rabbit. If it pleases the court, I shall proceed.
It pleases the court, but your co-counselor was very intelligently not responding to my question, so I will reiterate my question, because on this I don't think there is any paragraph in the compromise which will save you. The forced labor accusation comes from a report of an NGO only. So the question is, has the power, the authority to order further inquiries? Has the court the power to proceed to on-site visits? Are there limits to the power of the court in this respect?
Yes, Your Excellency. The court has the power to commission further studies, as it did in the Corfu Channel case. However, in this case, the forced labor submission of the applicant state is not merely reliant on the ILSA report or on Mr. Boyer's letter. There are several circumstances in this case that, as different facts, lead to the conclusion that in fact the Elysians were submitted to forced labor. And as
Sorry, but can the power proceed to an on-site visit, and do you know if can the court, proceed to an on-site visit, and do you know if the court has ever done that?
With respect to the first, to your question, Your Excellency, and no, I am unaware of any case in which the court has undertaken an on-site visit specifically. With respect to...
If I could seek clarification of one point. In your claim prayer for relief on the third issue, you asked the court to declare that the activities of Prof in Elysian, including the forced labour of civilians, are violations of international law. Could I ask, is it your case that it is something beyond forced labour? And if so, what other activities are you asking us to form a view about?
Yes, Your Excellency. It is the applicant state's submission that if this court decides that with the evidence presented, the forced labor cannot be clearly established, at least the agreed fact of the seizures of the Elysians by Prof men would constitute a breach to the right to freedom of movement, Your Excellencies. And therefore, this violation could also be established by this court because the seizures constitute a breach to such a right as established by this court in the hostages case, Your Excellency.
But aren't the seizures effectively part of the forced labour? Is it a separate claim that you're making there?
I'm sorry, Your Excellency?
Is it a separate claim that you're making when you refer to seizures, separate from the forced labour, which they would appear to be part of?
No, Your Excellency, and I apologize if I didn't make myself clear before. It is only an alternative submission in the case this court decides that forced labor cannot be established upon the evidence presented. However, it is the applicant state's submission that the violations committed against the Elysians were that of forced labor. Your Excellencies, this is a customary right, as evidenced by the ratification by 168 states of the ILO Forced Labor Convention, as well as by the express inclusion of such a prohibition in 126 constitutions of states of the international community. Your Excellencies, this prohibition entails, according to Article 2 of the ILO Forced Labor Convention, two elements to be fulfilled. Firstly, the involuntariness of the conduct of the person performing the work, and secondly, a menace of a penalty. In this case, it is the case's contention that both elements of forced labor were present, and that because of this, forced labor can be clearly established with respect to Prof's actions. With respect to the first element, Your Excellencies, the involuntariness, the ILO has signaled in one of its latest...
I think that indeed there is no dispute on the fact that Prof has probably done what they did. The real question for this court is, are those acts attributable to Rubria?
Certainly, Your Excellency. Addressing the issue of Rubria's responsibility, on this issue and on this connection, ACASUS has two main submissions, Your Excellencies. Firstly, that these actions can be attributed to Rubria under the direction and control rule reflected in Article 8 of the Articles of State Responsibility, because Rubria meets the overall control test applied and developed by the ICTY's appeal chamber in the Tadic decision, and that in the alternative, through these actions entail the responsibility of Rubria for breaching its due diligence obligations regarding the Elysians' human rights.
Was there any directive given to these people to act the way they did, grab them in off the land and take them to forced labor, as you allege? Was there, so on what, is it the overall control according to Tadic?
Yes, Your Excellency. It is not the applicant state's submission that the effective control test applied in the Nicaragua case is met in this case. It is the applicant state's contention that the overall control test applied in the Tadic decision and also in the Alevskovsky decision.
You're mentioning the Tadic decision, which is an important one, but isn't that the decision of this court on matters pretty close to the one that we are discussing on the control of one state? And what was the final outcome of the decision of the court in that case?
Yeah.
You are mentioning the control, okay? And you are referring to the Tadic case, which is an important one, but it's not one of the ICJ. So I'm asking you if there is a decision of the ICJ on issues similar to the ones we are discussing today about the control of state on private individuals, and what was, if you can mention the decision, what was the final decision of the court on that case?
Yes, Your Excellency, I believe you are referring to the Nicaragua case. In that case, the degree of control required to attribute the conduct of the Contras to the United States was that of effective control, which required specific instructions. However, Your Excellencies, it has been 20 years since that test of control was applied. And as pointed out by Justice Koijans in the Congo versus Uganda case, the court has missed the opportunity to rule on the issue of control.
I mean, I'm not personally affected by your criticism of the court. I just wonder whether maybe for future Jessup teams, but also in this context, the better way of arguing would be to try to distinguish the Tadic case from the Nicaragua case. Could you try to do that instead of criticizing us?
Yes, Your Excellency, and I apologize if I wasn't expressing myself correctly. There are main differences between this case and the Nicaragua case. In the Nicaragua case, Your Excellencies, the actions of the Contras were out of the jurisdiction of the United States, and the effective control test was applied in order to determine if, in fact, the United States had control over this paramilitary group. In this case, Your Excellencies, the situation in the forced labor took place within Rubrian territory, and this together with the fact that, for example, there were former members of the Rubrian armed forces forming part of PROF, Your Excellencies, as was a circumstance also in the Tadic decision.
Wouldn't there be alternative ways of arriving at the responsibility of the territorial state than going the route that you now went?
Yes, Your Excellency, certainly. There is the alternative. It is a casus alternative argument that these actions constitute a breach by Rubria of its due diligence obligation regarding the Elysian's human rights. Your Excellencies, all states have a due diligence obligation regarding the human rights of persons within its jurisdiction, as stated by the
I'm puzzled by this. I'm puzzled because the people we're talking about are situated in Acastus. They are not situated in Rubria. So those activities, the people were, if they have been abducted, if they are being taken away, those people were entering into the Acastus territory, seizing the persons, bringing them in Rubria, bringing them back in the Acastus territory. So if there is a failure of due diligence, isn't it at least a shared responsibility of both states? Because, I mean, apparently people could come, cross the borders with arms, take away people in your territory, take them in another third party, coming back, and do that for at least 10 times in 2 months.
With all due respect, Your Excellency, may I defer? According to the compromis, all seizing by Prof men occurred in the agricultural fields located in Rubria. There was no seizing occurring within Acastus.
I wonder, before we leave this question of attribution, you could take us to the International Law Commission's articles on state responsibility and indicate what weight we should give to those and what answers they might give us.
Certainly, Your Excellency. The Articles of State Responsibility were adopted by the General Assembly without a vote, and they constitute some articles.
Is that true? Were they adopted without a vote?
Yes, Your Excellency. Then I apologize, Your Excellency. However, the articles are not a convention or do not constitute...
What did the General Assembly do with these articles? Because this is not just a kind of a silly question, but there was quite a bit of a political element behind the way the General Assembly treated these articles. And I think my distinguished co-judge was not entirely innocent of the... It was not adopted. Why do you think, could it be, just if you assume that I am right, why did could the General Assembly have had hesitation to adopt the articles, just adopt them without a vote?
I understand, Your Excellency, I will rephrase my before answer. They were not adopted by the General Assembly, they were merely attached to a resolution of the General Assembly.
What did the resolution say? Because it has to say something. The General Assembly, blah, 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 and then at the end?
Yes, Your Excellency, because there was no general agreement of the states regarding all the articles in the Articles of State Responsibility, because some articles do codify custom, but some others constitute a progressive development of the law on state responsibility.
Give me an example.
For example, Article 4 regarding the responsibility of states because of their organs, Your Excellencies, has been considered customary international law, and expressed as such by, for example, Professor Crawford, former Special Rapporteur of the International Law Commission on State Responsibility.
And an example of progressive development?
Your Excellency, that would refer to I'm aware of the specific number, but I believe the article on countermeasures has been considered a progressive development of international law on state responsibility.
Okay, articles entitling states to resort to countermeasures be called a progressive development of international law in view of the fact that in many, many cases they are an abuse and the exercise of power by the stronger on the weaker.
Because it regulates, Your Excellency, a whole situation that wasn't before specifically and objectively regulated, that was undertaken by states without a specific legal provisions. However, Your Excellencies, turning to the issue of the responsibility of rubria, which was based on Article 8 as a form of attribution, which has also been considered customary international law, and with regardless specifically to the due diligence obligation Rubria had with respect to the Elysian's human rights, Your Excellencies, we note that the obligation of due diligence entails the obligation to prevent, the obligation to investigate, the obligation to identify those responsible, the obligation to punish, and the obligation to compensate for human rights violations. ACASTOS believe that all of these obligations were breached by Rubria. However, we shall concentrate on the obligation to prosecute and the obligation to prevent, Your Excellencies. May I refer, Your Excellencies, to clarification 10 of the compromise, where it is clearly stated that the Elysians exhausted all local remedies. This means, Your Excellencies, that the Elysians already went to the Rubian courts and they were denied all remedies within the Rubian judicial system, Your Excellencies. We are aware that Rubria claims to be currently investigating these issues. However, since there is res judicata, Your Excellencies, these cases cannot be opened again, and therefore no proper prosecution would have been undertaken by Rubria. With respect to the obligation to prevent, Your Excellencies, we note that as stated by this court in
Can I ask, Counsel, is there an obligation to prevent something when you don't know that it's happening?
No, Your Excellencies, and it is precisely the applicant state's submission that at least Rubria should have known of these unlawful activities on the basis of the constructive knowledge established by this court, for example, in the Corfuciano case. In this case, there are several circumstances that lead to the constructive knowledge of Rubria of these unlawful activities. These forced labor, Your Excellencies, took place several times in a short time span. It took place at several COG work sites. It involved several of Prof trucks, Your Excellencies, and it took place for long hours during the whole day. It also took place, Your Excellencies, within a national park that was under the stewardship of the National Parks Authority, an agency of the Rubian government. It took place for the benefit and in connection with a project that was vital for the developing economy of Rubria, Your Excellencies, and that, as evidence in the practice of states, are closely watched by states, such as, for example, in Myanmar, Sudan, and Nigeria, Your Excellencies. All these circumstances, Your Excellencies, lead to the conclusion that at least Rubria should have known of these unlawful activities, and that therefore it failed to prevent such forced labor by allowing it to continue. Your Excellencies, having argued how this forced labor does make Rubria responsible, the
question with regards to the conditions, the labor conditions. One thing which is established as a fact is that the people taken from Elysian were given sorghum. Now, my impression from the facts is that the food situation of these people was pretty bad. And I've read about the sorghum being a very nutritious, let's say, kind of food or whatever. So under the circumstances, it's not to be regarded as an adequate food in the sense of the Covenant on Economic and Social Rights you are so well aware of?
No, Your Excellency. Firstly, because there is no evidence in the compromise that the Elysians were malnourished. And secondly, but because in any case, the ILO Commission of Inquiry of Myanmar has signaled that the payment, even if it were in kind or as it should be in cash, does not exclude the fact that this is forced labor, Your Excellencies. With respect to the applicant state's last submission, by way of defense, Your Excellencies, Acasus contends that it did not breach Article 52 of the RABIT by virtue of the outcome of the Boreas litigation. Under Article 52, Your Excellencies, Acasus undertook to enforce all aspects of its domestic law. The obligation, Your Excellencies, was to enforce local laws. And the issue here was if Acasus did or did not enforce its local laws.
Could you enlighten me on what could be seen as a contradiction? And let me explain to you. In page 27 of your memorial, you say TNC does not exercise excessive control over COG. Indeed, the normal oversight exercised by shareholders does not qualify as control. Fine. But then, a few pages later, you say, page 31, you say that COG is not a foreign control enterprise since its majority shareholders is TNC. So either TNC controls because it is a majority shareholder and then it is a domestic corporation, as you suggest in page 31, because you say it's not a foreign control enterprise, or it doesn't control. Does it control or it doesn't control?
Your Excellency, TNC is a majority shareholder in
But does it
COG.
control or it doesn't control?
No, Your Excellency, it doesn't control the company.
So what you're suggesting is that a majority shareholder does not control the company.
No, Your Excellency, and allow me to rephrase my answer in order to explain myself clearly. TNC is the majority shareholder and therefore exercises majority voting within the meetings of the shareholders. And therefore, TNC could qualify for the most national treatment instrument of the OECD as a foreign controlled enterprise. However, in order to lift a company's corporate veil, majority shareholding or majority control in the shareholders meeting is not enough. And however, on that particular point, allow me to depart from our written submissions, because in this case, the issue would only be if Acasus did or not enforce its domestic law, and it is Acasus' contention that it did, Your Excellencies, because enforcement, as stated by scholars such as Professor Nowak and Rautiola, means an effective application of the law. An effective application of the law with regard to TNC, Your Excellencies, would entail that where the law is inapplicable to a defendant, the law must be not enforced upon that defendant. In the context of the board's complaint, Your Excellency, there was no action that was complained of in that suit that was carried out by TNC. Therefore, because all actions were carried out by COG or PROV, the action... Yes, Your Excellency.
Yes, Counsel. As I said, time is running. So let me go to, at the end of the day, what is the most important task of this court, which is to decide the case. What exactly are you looking for?
Your Excellency, I see that my time is up. May I answer your question?
Very brief, very brief.
For a declaratory judgment, Your Excellencies, that Rubia is responsible and that it did not breach, and that Acasus did not breach Article 52 of the RABIT.
So you're not asking for any order to not continue the construction of the pipeline, which for the moment is only suspended?
No, Your Excellencies, as evidenced in paragraphs 37 and 38 of the compromise, both parties agreed to ask for declaratory judgments to this court.
Thank you. Your time is up. If I got the rules right, it's now for the respondent to take the floor. Okay? Counsel, you have the floor.
Thank you, Mr. President. Mr. President, Your Excellencies, may it please the court. My name is Vincent Levy, and I appear before you today as an agent for the state of Rubria, the respondent in this case. I will speak for 22 minutes and argue first that this court lacks jurisdiction over all claims aside from those under the Rabbit. Second, I will argue that by permitting the construction of a pipeline in the Elysian, Rubria will not be violating any international legal obligation. My co-agent, Tracy Appleton, will speak for 21 minutes. She will argue first that Rubria is not in breach. Rubria has not committed any violations of forced labor. And second, Your Excellency, that Acastus is in breach of Article 52 of the Rabbit. And we reserve, Your Excellency, 2 minutes for rebuttal. Turning with your permission to our first submission, that this court lacks jurisdiction over all claims aside from those under the Rabbit.
Could you maybe get a little closer to the microphone, or the microphone a little closer to you? Yes. Okay.
Yes. Thank you, Mr. President. Turning first to our contention relating to the jurisdiction of this court, the applicant has stated that this court would lack jurisdiction over the Rabbit if it were to find that Acastus were not a member of the United Nations. We would first point this court in the direction of Resolution 9 of the Security Council, which highlights the conditions for appearance of non-parties before this court under Article 35(2) of the statute of this court, Your Excellency. We submit that in Article 4 of the Compromis that precedes the statement of facts, both states have agreed to carry out the judgment of the court in good faith. And therefore, we do submit, Your Excellencies, that the requirements of Resolution 9 are satisfied here with respect to the Rabbit. If this court were to find that they are not, we do concede, Your Excellencies, that this court does lack jurisdiction over the Rabbit claim per the use of force case, which was alluded to by the agent from Acastus. With respect, Your Excellencies, to the invocation of our Article 36...
Could we just go to that use of force case? Because on the face of it, the language of Article 35, paragraph 2 is rather clear. It says, subject to the special provisions contained in treaties in force. And you had a treaty, you entered into a treaty with Acastia that provided for the jurisdiction of the court. So why shouldn't the court have jurisdiction under Article 35, paragraph 2?
Your Excellency, in that case, the court stated several reasons. It looked at the statute of the court as a treaty, which it is, and applied the Vienna Conventional Law of Treaties as reflective of customary international law. And it looked to the travaux préparatoires of the statute of the predecessor to this court, the Court of International Justice. And it found, Your Excellency, that the same phrase appeared there, and it was meant to refer to the treaties of peace following World War I. With the adoption, the explicit adoption of that language in Article 35(2) of the statute of this court, the court stated that it should be presumed, and the court so held, that statutes in force meant statutes that were in force as of the date of entry into force of the statute of the court.
And you're not asking this court to review its decision of 2004 in this particular case?
We are not, Your Excellency. In that decision, the court did state that we should provide a compelling reason or a good reason for the court to disregard its precedent. So while there is no doctrine of stare decisis in international law, the court does treat its prior decisions with some respect, Your Excellency, and so shall we. Your Excellencies, turning to the claim of continuation, of membership in the UN or otherwise of jurisdiction and invocation of our Article 36(2) declaration. The agent from Acastus raised 3 grounds. The first was of continuation. They also claimed that Resolution 2386 was inapposite. And finally, they claimed, though they did not argue at oral arguments, that the sui generis position of Acastus provided this court with jurisdiction. I presume, Your Excellency, that by that they mean something like the position of the Federal Republic of Yugoslavia. Now, in the use of force case to which Your Excellency referred, the court only looked to whether the Federal Republic of Yugoslavia had been a member of the United Nations during those relevant years, 1992 through 2000, and whether otherwise it could appear under Article 35(2) of the statute of this court. And for the reasons that stated in that case, Your Excellency, it found that jurisdiction was lacking. And support for this view, Your Excellency, is provided in the Charter, which, under Article 93.1, makes UN members a party to the statute. Now, with respect to members, Your Excellencies, those are defined in Chapter 2 of the UN Charter. They have to be admitted under Article 4.2, which the court has analyzed with some depth in 1950 in a decision concerning the competence of the General Assembly for the admission of states.
Counsel, but all this is very good, but if the court accepts the claim of Acastus that it is a continuation, all those arguments are so abundant.
Absolutely, Your
So
Excellency.
why don't we start with maybe the main argument, which is that Acastus claims to be the continuation?
Absolutely, Your Excellency. We wish to first turn to the resolution of the Security Council. Now, the Security Council has spoken on the issue, and we read the Security Council somewhat differently than the agent from Acastus. The Security Council, quote, decides that Acastus should apply for membership. Insofar it is used as the Security Council uses those words, it echoes the prior resolutions concerning the Federal Republic of Yugoslavia. If we look, Your Excellencies, to Resolution 777, that resolution recommended to the General Assembly that it decide that the Federal Republic of Yugoslavia should apply for membership. And the General Assembly so did in Resolution 47.1.
Could I ask whether you think that the Security Council was within its powers when, on this occasion, it decided that Acastus should apply for membership?
Your Excellency, we certainly concede that there is no explicit provision in the Charter that would grant the Security Council such a power.
What are the nearest provisions? And
Well-
what do they say for the Security Council?
Your Excellency, if we look to Article 25, that article does state that decisions of the Security Council should be carried out by the member states. Now, the
It
applicant...
doesn't quite say that, does it? It says the members agree to carry out the decisions of the Security Council in accordance with the present Charter. What do those words add?
Those words do imply a certain limitation of powers, Your Excellency. At the same time, we would point this court in the direction of its decision in the certain expenses case, where it said two very important things. First, that the actions of the political organs of the United Nations are to have a presumption of validity. And at the outset...
Don't you think it's relevant that Articles 4, 5 and 6, which deal with membership issues, largely give the Security Council the power to recommend to the Assembly?
Your Excellency, it certainly is relevant. And we would submit, Your Excellency, that even were this court to determine that this is a mere recommendation, the court should still find that Acastus has failed its burden to overcome the presumption in this case that the Security Council has provided. Now, before I turn to that argument...
Could you also, please, address us on the significance of the Under-Secretary General's interpretation? Because he said that Acastus was not prevented from temporarily continuing the membership. So, presumably, Acastus is a member.
Absolutely, Your Excellency. The Undersecretary General said that Acastus could temporarily continue the membership of its predecessor. Now, continuation means that a state has retained the legal identity of its predecessor. Therefore, we submit that the words temporary and continuation together do not make a whole lot of sense, and that at best it indicates the existence of a sui generis position, which was what we were addressing to earlier. And Your Excellency, this also underscores the fact that the claim that Acastus makes, that the subjective views of the member states are such that they recognize the continuation of Nessus is Acastus, must be measured by the fact that it was in light of this both Security Council resolution and this opinion, which is admittedly not binding, but which does provide for temporary membership, Your Excellency. And therefore, we submit that at best, the acquiescence of the United Nations is to a temporary membership, which we submit is not sufficient for jurisdiction.
Why?
Your Excellency, turning to that issue, first, we submit that because to appear before this court as a member, as a party to the statute under Article 35.1, a state must be a party to the statute under either Article 93.1 of the Charter or Article 93.2. Now, the provision that should be relied upon here is Article 93.1. There is no contention here that they have applied to become a party to the statute without being a member of the UN. Since, Your Excellency, we submit that the membership of states is defined in Chapter 2 of the Charter, and we do concede that it would apply to continuation states. If Acastus is a mere temporary member, then it does not have the full rights of membership. Furthermore, Your Excellency, we would point this court...
Well, you are creating a new category of temporary members, which I was not aware. But the question for the court is very simple, in my view. Was Acastus a member of the UN when the facts happened? Now, you mentioned the opinion of the Undersecretary General, but what about the practice of the General Assembly? What about the fact that there has been a representative of Acastus behind nameplates in the General Assembly? Probably and certainly, even though the compromise doesn't say it explicitly, the credentials have been approved by the Credentials Committee. I don't know if you were a member of the Credentials Committee. The flag has been flown. The government has assumed financial obligations, and I'm pretty sure that Nessus did not object to the payment of the financial dues by Acastus. So,
Your Excellency, all these go to the actions of the General Assembly and the Secretariat, and we would point this court first in the direction of its 1950 decision concerning the competence of the General Assembly. In that case, this court stated that the General Assembly did not have the power alone to admit a state. Under Article 4.2, there has to be a prior recommendation.
But we're not talking about admission of new state. We're talking about continuation.
Absolutely, Your Excellency. And we submit merely that the actions of the states during the relevant period must be analyzed in terms of the opinion of the Undersecretary General, which provides for temporary participation in the General Assembly, and which we submit is not sufficient for appearance before this court. The other reason, Your Excellency, that such appearance is inappropriate is that if it is true, Your Excellency, that Acastus is not the continuation of Nessus, then it cannot use Nessus's former declaration under Article 36.2, Your Excellencies. Indeed, the declaration must have lapsed. So the only formality that must be met to make an Article 36.2 here is that a statement must go to the Secretary General. That much is clear from to the Secretary General. That much is clear from Article 36.4 of the statute. Now, if we look also to this court's decision concerning the temple of Priya Vihar, the relevant consideration, if the formality has been met, which we do concede it has by virtue of the statement of Acastus claiming continuation, the relevant question is what intent is evidenced by such declaration. And we submit here that the intent to be bound by the jurisdiction of this court is lacking. Because, Your Excellency, it is a unilateral declaration, the intent must be clear. So much has been said many times by this court, starting at least with the case concerning the nuclear tests. Now, supposing that this court, before I turn, Your Excellency, to the question on the merits of the pipeline, I do wish to correct one point that the agent from Acastus has made. They have stated that Article 25 only applies to Chapter 7 and have cited the Namibia case. There is certainly support in the scholarship, in legal scholarship, to sustain the view that Article 25 only applies to Chapter 7 powers. However, the Namibia decision is not such a support. That decision specifically provides, if I may read from the decision, it has been contended that Article 25 of the Charter applies only to enforcement measures adopted under Chapter 7 of the Charter. It is not possible to find in the Charter any support for this view. And
could you tell us what happened when this opinion went back to the Security Council?
I do not have that information in front of me, Your Excellencies. I do apologize.
It may have been that certain states objected to that statement by the International Court.
Your Excellencies, we do not debate that there is a lot of controversy in this area and do not rest exclusively on Article 25. We do suggest, however, that there is support both in this court's jurisprudence as well as in the legal scholarship of such noted publicists as Professor Jose Alvarez, for such a position.
Could it have been that the view of the court in 1971 on from which you just read might have made some sense during the Cold War, but is really obsolete and not necessary anymore nowadays, so that view could not really put forward with great, let's say, power of conviction?
Admittedly so, Your Excellency. We do submit, however, that in the case of membership, which is after all a case of internal organization, since the court has decided in the use of force case that a joint resolution by the Security Council and the General Assembly was not sufficient to decide of the issue, we do point to that decision for the proposition that in terms of institutional effectiveness, there has to be some power within the political organs to decide these issues.
Maybe we should move to the merits.
Absolutely, Your Excellency. Should this court find that it has jurisdiction over all claims because Acastus will be a continuation of Nessus, we submit that Rubria acts within its sovereign rights in permitting the construction of a pipeline over the Elysian. Now, the agent from Acastus has pointed this court pretty much exclusively to Article 27 of the ICCPR, which we can see is on point here. We do contest, however, the characterization of the agent from Acastus that there is an essential link between the activity concerned and the culture of the Elysians. There is simply no showing in the compromis that this is so. In fact, if the court looks to paragraph 3, that paragraph of the compromis, Your Excellencies, that paragraph makes clear.
Could I ask, do you accept that Acasta is a party to the covenant?
Your Excellency, if were this court to find that it has jurisdiction, we would certainly concede that Acastus is a party to the statute.
Why is that?
Because as the continuation state, Your Excellency, it would be the continuation of Nessus. It also has made a statement that it would continue to be bound by all the treaty obligations of Nessus, its predecessor, and Nessus itself was a party to the ICCPR.
And is the fact that the covenant is a human rights treaty relevant to this question as well?
I apologize, Your Excellency, I didn't hear your question.
Is the fact that the covenant is a human rights treaty also relevant, possibly?
Yes, Your Excellency, this court has certainly stated many times that human rights obligations do carry on upon the dissolution of the state. And
You said many times. Could you give me 4 in
well, at least Your Excellency has pointed in this.
8.
At least in the case concerning the former Yugoslav Republic, the court did speak to the obligations of human rights in the case of dissolution, if we look to the Genocide Convention, Your Excellency.
But did the court say in this case that the human rights obligations run with the land? Did the court really accept that just like that?
Not at all, Your Excellency. In terms of access to the land, the court must look instead to Human Rights Committee cases. This court itself, as far as we know, has not addressed this issue specifically. Now, the Human Rights Committee in both cases, and in its general comment, does say that Article 27 protects land rights when those land rights are linked to culture. Now, for instance, Your Excellency, in the Mahuika case, this concerned the rights of the Maori of New Zealand to their fishing. And there was a lot of evidence in that case, Your Excellency, to show that the fishing was intricately connected with the culture. And we simply submit that such evidence is lacking. But Your Excellencies, even if we assume that Article 27 is implicated, the next relevant question becomes one of balancing the rights of the Rubrians with those of the Elysians.
You strongly argue that basically you enjoy permanent sovereignty over your natural resources and therefore you should be able to do whatever you deem appropriate. And you mention in page 14, Rubria enjoys permanent sovereignty over its natural resources in Rubrian Elysium under general international law. And the general international law that you mention in the footnote 108 is mainly, well, the first 2 documents that you are mentioning are the Declaration on the Establishment of a New Economic Order and the General Assembly Resolution 3281. Now, what is the legal weight of those two General Assembly resolutions?
General Assembly resolutions do not appear specifically in Article 38, Your Excellency. Certain noted publicists, including Ian Brownlee, have noted that by participating in the General Assembly, states may express the
Let me maybe try to be more specific. Do you know what were the conditions of adoptions of those two resolutions?
I am not sure, Your Excellency.
So that the developed countries either voted against or abstained on those two resolutions, and you are an OECD member, so you're a developed country, and as such, it's a bit strange that those resolutions, which are highly controversial and for which a number of countries abstained or voted against, are mentioned.
Your Excellency, we do not need to rely upon general international law, as the principle is codified in the ICCPR itself in Article 1.2. Now, that article specifically provides that all peoples have the right of permanent sovereignty over their natural resources.
But doesn't that kind of protect the Elysians rather than you?
At first reading, we do concede, Your Excellency, that this is a possible reading. However, if we look to the surrounding articles, we submit that the peoples concerned are those that belong to states, as well as those that are under colonial rules. In fact, Article 1.3 specifically speaks to trust territories as well as non-self-governing territories. Furthermore, if we look to the travaux préparatoires, it is very clear, Your Excellency, that the signatories and the parties to the covenant specifically meant to exclude indigenous peoples and other minorities. Your Excellencies, I see that my time is up. If you have any more questions.
Well, better not. Thank you very much. So I thank you, and I call on co-agent or co-counsel for the respondent. You have the floor.
Thank you, Mr. President. Good afternoon, Mr. President, Your Excellencies. May it please this Court. My name is Tracy Appleton, and I appear before you today on behalf of the state of Rubria. I will argue first that Rubria is not responsible for the alleged actions of Prof. Second, I will argue that Acastus is in breach of Article 52 of the Rabbit by virtue of laborious litigation. Now, the agent of Acastus has raised two main arguments before this Court today regarding the attribution or responsibility for Prof's actions. The first argument that the agent of Acastus made was under Article 8 of the Articles on State Responsibility. Specifically, they alleged that there was direction or control over Prof by Rubria. Now, as your
Do you know what Article 8 says? There are three kind of links or criteria.
Your Excellency, in terms of Article 8, it essentially says that the persons or a group of persons, in fact, they must be carrying out the instructions of or be under the direction or control of that state in carrying.
Right. Do you happen to know what the article said in their first reading text of 1996? Because that is the end product. Mm-hmm. And it was not, that wording was not contained in the texts until, I would say, about 1999 to 2000.
I beg your pardon, Mr. President, I do not have that earlier text. However, the agent of Acastus also referred to a couple of cases, including the case of Nicaragua before this Court. In that case, this Court found that the United States did not have effective control over the Contras, mainly because they did not enter into jurisdiction with the Contras and did not fight alongside them, even though the United States was financing, helping them plan, helping them pick targets. This, Your Excellencies, was insufficient in order to find effective control. At the same time, they did accompany, agents of the United States did accompany the UCLAs, and that was found sufficient. Now,
How about an obligation to prevent certain things from happening?
absolutely, Your Excellency, that would be the second contention that Acasis raised, which was the argument on due diligence. I would turn to that now if Your Excellency would prefer. Certainly. Now, beg your pardon, with regard to the argument on due diligence, just as a preliminary matter, the agent of Acasis mentioned the duty to prosecute and turned Your Excellencies to...
On this question of exactly what is your power of control, maybe I'm wrong again because I've already been wrong a couple of times on the facts, but I see here in page 20 that you say no, not one of COG board's member or employee is a Rubrian official. Now, it is clearly stated so for employees. For board member, I see that 4 of the members are appointed by the government of Rubria. We don't know if they are Rubrian of public officials or not, but they are appointed by the government of Rubria.
That is true, Your Excellency, and according to, I believe, paragraph 5 of the clarifications, it does say that Rubria appointed 4 members and that TNC appointed 5. Then,
so doesn't this at least give a certain degree of control of Rubria on this corporation?
no, Your Excellency. If I may make a comparison, in an independent tribunal case, Liverpool AG, the government of Qatar, in that case, the Qatari government owned the entire corporation in question, appointed all the board members, and yet the court in that case found that this was insufficient in order to show control. In fact...
What court was that?
It was an independent arbitral tribunal, Your Excellency.
What do you mean by independent arbitral? Aren't they all independent?
Well, at least in mind, we hope so, Your Excellency. But in terms of just an independent tribunal as opposed to one that was established as the... I'm sorry?
You want to say ad hoc?
Ad hoc. Beg your pardon, Your Excellency. In that case, I believe the number was a total of 4 or 7 of the board members were active members of the Qatari government. And in fact, the CEO was also the head of a ministry and was shuffling back and forth between the corporation and the Qatari government.
Can I ask what weight this court should give to one ad hoc tribunal decision?
Your Excellency, this agent merely raises it as an example of the difference between the kind of the case at hand in terms of appointing someone who is actually a member of the government and the case at hand where there is no mention that any Rubrian officials were on the board. Now,
sorry, could I take you back to the state responsibility draft articles, which appear to give answers to these issues? What status do they have as a matter of international law in your view?
well, Your Excellency, as the agent of Cassis was indicating before, the ILC articles were noted by the General Assembly in 2004. The articles themselves were written by 34 internationally renowned experts in international law, and they were essentially an attempt to codify customary international law and general principles of international law. Therefore, Your Excellencies, you could look to the articles themselves under Article 38(1)D of the statute, and in terms of what they codify, you could look to Article 38(1)B and 1C.
Counsel, can you mention cases, precedents in which the court look at draft articles of a convention or ongoing work?
In terms of ongoing war, Your Excellency?
Yes. In which can you mention cases in which the ICJ decision explicitly referred to ongoing work which had not been finalized yet?
A decision that has not been finalized yet?
No, the decision was finalized. The ongoing work to which the court was not finalized.
Work of the ILC.
Exactly.
On state responsibility.
Certainly, to be honest, Your Excellency, I know that the court has specifically mentioned Article 5 before, but I do not remember the exact case that they did so. However, it has been mentioned in other cases, and if Your Excellencies would permit me, I would be happy to turn to either the decision in Tadic to address that, or...
Yeah, right, but let me, I'm very sorry, but there was a case in which the court referred to the article on breach, on change of circumstances, on necessity, You don't know what case I'm talking about? All right, go on.
Beg your pardon, Mr. President. I mean, in terms of well, turning back to due diligence, which Your Excellency mentioned a moment ago. First, that turning to clarification, paragraph 10. The clarification says that the Elysians have exhausted all remedies. Now, Rubria would contend that that refers to civil remedies. And in contrast to what the agent of Acastus alleged, this does not prevent a criminal prosecution. In fact, in paragraph 1 of the clarifications, that makes clear that Rubria is aware of the violations and has a prosecution investigation ongoing. Now, in terms of the duty to prevent, the agent of Acastus mentioned Corfu Channel as a standard that this court may look to. Now, briefly, in the diplomatic and consular staff case.
Excuse me. Where in international law do you find authority for the statement that the duty to prevent involves or encompasses a duty to criminally prosecute?
Well, Your Excellency, this court could look to a number of sources, including the Velazquez-Rodriguez case, which was an Inter-American Court of Human Rights case. You could turn to the Boyd decision, which is a U.S.-Mexico Claims Tribunal case. You could look as early to the Alabama claims decision in terms of knowledge and that having to support due diligence. But in essence, it is true, specifically in the diplomatic and consular staff case, they found that once they knew... Oh, beg your pardon, Your Excellency. This court found that when a state has knowledge of a possible violation, they must use all means at their disposal in order to prevent it. And Rubria would point specifically to that prong of knowledge in this case. Now, in Corfu Channel, the court allowed for constructive notice, or essentially using circumstantial evidence.
The president of this court comes from the continental law tradition, and just happens never have to have heard the term constructive knowledge. Could you explain?
Certainly, Your Excellency. In Corfu Channel, the Albanian government was accused of knowing that the mines were laid within Corfu Channel. The difficulty was that Britain could not access evidence in order to prove that knowledge. Therefore, this court held on page 18 of that decision that Britain could bring forth circumstantial evidence in order to show that Albania must have known about the mine laying. So
did the court use the term constructive knowledge?
They used constructive notice, Your Excellency. I do apologize, I believe. Now, in terms of using the circumstantial evidence on that page 18, the court first made the point that the mere fact that a violation occurs on one's territory is insufficient in order to attribute knowledge.
Excuse me, is this page 18 of the judgment or page 18 in the ICJ report of the year in which you find Corfu Channel?
Your Excellency, I believe it's page 18 of the judgment. Now, in terms of the level of proof that must be shown on page 18 of that decision, it shows, beg your pardon, Mr. President, it essentially says that the evidence must rise to a level where it is beyond any reasonable doubt that it proves that there was knowledge. In that case, Your Excellencies, the Albanian government had told the world that it was constantly watching the Corfu Channel. It had told, its delegate had told the Security Council as such. They found orders to their individual guards that they were to...
I'm sorry, but I had the impression that this court has in more recent judgment not referred to the formula beyond reasonable doubt. Where at The Hague would you rather find use of that formula?
Mr. President, I believe you are referring to perhaps the case of the Congo, in which it was another due diligence breach. In that case, Your Excellency, there was evidence that the military was actively watching the violations that were occurring. Now, this is in vast contrast to this case in which there was awareness, and Your Excellencies can turn to paragraph 23 of the compromise, that there could be hostilities. And that was the reason that PROF was created. PROF was created as a private security force to accompany and guard PROF.
Can I ask, Council, are you admitting that Rubria doesn't really control all parts of its territory? You have a parks authority, but it apparently doesn't see what's going on in the park.
No, Your Excellency. In terms of control, there are certainly parks authorities that have stewardship over the Elysian, and that's in paragraph 5 of the compromise. This is in vast contrast to such a situation as Article 9 of the draft articles, in which there is an absence of government authority. That specifically applies to cases of revolution or complete breakdown of the government. The question here is not whether they had enough people available to protect against this happening, but whether they knew beforehand and had the notice in order to use such personnel. The compromise is silent as to whether the Elysians ever notified the Rubrian government of what was happening or the alleged actions of PROF. It was only after Rubria became aware of the situation that they were able to act, and Rubria would put forth that they are doing so. Now, Your Excellencies, if I may...
Just one quick question.
Certainly.
Is it draft articles or articles?
Beg your pardon?
You know, you spoke of draft articles, which is the ILC on state responsibility. Is it draft articles or simply articles?
They are simply, they have been referred to as the draft articles, having been noted. They haven't been, I believe they have not been formally ratified, but simply noted by the General Assembly.
Do states have to ratify the draft articles on state responsibility?
It's not necessary, Your Excellency, for them to ratify them in the sense that they can still be used as I mentioned previously to...
Can they be ratified if a state was willing to do?
Your Excellency, I would presume that they could be ratified if they were put forth as a general treaty. However, given the discussion earlier, this has not been possible to ratify the articles in general.
Is it if they would be put forward as a treaty, who is they?
If individual states wanted to put it forth as a treaty, perhaps they could. If the General Assembly wanted to open it up for signature and ratification, perhaps they could. But essentially, in the General Assembly, it has been noted, and that's essentially what I know from since 2004. Now, with regard to the second issue, Your Excellencies, with regard to the MICRA, the difficulty that Rubria has with Acacis's interpretation of the rabbit is that it essentially renders the treaty a nullity, which is a result that this court has frowned upon, both in the Namibia case and more recently in the fisheries case. If we turn to paragraph 15 of the compromise, it has the text of Article 52 of the rabbit. The agents of Acacis have focused upon their obligation to enforce all aspects of their domestic law, including the MICRA. Now, looking to the rest of the text, which this court can do under the VCLT Article 31, we see that they are their obligation, or what they are meant to do, is to enforce all aspects of their domestic law in carrying out their obligations of the treaty. In that first sentence, Your Excellencies, it says that the parties note that Acacis has passed the Multinational Corporate Responsibility Act, the terms of which are hereby incorporated by reference. Now, Rubria realizes that this is a very unusual situation where the language of a domestic law has been transplanted into a treaty, but this is what Rubria would contend, this is exactly the case. And it is the language of the MICRA that contains the obligations that Acacis is bound by. Now,
Council, if we could jump a little.
Certainly.
We do jump because we need to get to the points that really concern us. I'm really concerned under this item about the issue of immunity. And the applicant in their memorial assert that there is no immunity in the case of human rights violations. And they say scholars increasingly sustain that states do not have immunity when they breach their international human rights obligations. And I wonder if you could address that. Firstly, so what? Scholars increasingly assert. What's the importance of scholarship in this field? And secondly, what's the position of the respondent on the substance of this assertion?
Well, Your Excellency, in terms of your first question about scholarship, as no doubt the agent of Acastus would note, this scholarship, if they are truly learned scholars, can be looked to as a supplementary means of determining the law under Article 38(1)d of this court statute. Now, in terms of Rubria's reaction to whether states have immunity for human rights violations, this they would not necessarily have a blanket immunity for human rights violations. A state could certainly bring an action before a court such as this one in such a case. However, the question here is whether they are immune in terms of a domestic court's decision. Now, in their...
Sorry, am I correct I think I had understood that you were suggesting that immunities could be brought in front of this court, but not on human rights, but on other. I mean, could a state refuse to appear to this court, in front of this court, because it has immunity from jurisdiction?
Your Excellency, if they have not conceded to jurisdiction previously, then they could make the argument that there would not be.
Is this a question of immunity, or is this a question of lack of jurisdiction?
Beg your pardon?
Is this a question of immunity, or is this a question of lack of jurisdiction?
This is a question of lack of jurisdiction, Your Excellency. Now, in terms of the domestic court's decision, they do discuss their state's FISA statute, and Acastus does not, beg your pardon, Rubria does not wish to focus on their FISA statute specifically because we do not have that text before us. Rubria would simply underline the fact that the rabbit is...
From the quote we have.
Your Excellency...
What does it remind you of?
Beg your pardon?
Does it remind you of other countries' statutes?
Certainly, Your Excellency, in terms of the commercial activity. There is another statute in question in the compromis, the Ares, which is also could be very familiar in terms of domestic law. Essentially, there are two areas in which Acastus has breached its obligations in terms of the Boreas Court's decision. First, that by the terms of the MICRA, it gives Acastian courts, beg your pardon, Acastian corporations.
I'm so sorry. Do you consider that the Ares is a statute which is in breach of international law, or could be seen in breach of international law?
Your Excellency, Rubria would argue as such in the sense that the Ares statute is a domestic law, and Rubria does not argue that it arises itself to international obligations. However, the Boreas Court, if we look to paragraph 28 of the compromis, the Boreas Court found that the Ares statute did not fall upon TNC because corporations are not subject to international law. That was the language used. Subsequently, in paragraph 30 of the compromis and 31 of the compromis, they found that COG, Your Excellencies, may I complete my sentence?
Very briefly finish the argument, but
they found that COG was liable as a commercial, as a corporation, thereby showing that they were deciding arbitrarily, and this would be a denial of justice under customary international law.
Thank you very much. If I get the rules correct, right, time is up. The court will now. Oh, sorry, time is not up. But for a very brief. Okay. Right, go ahead. 2 minutes, yes.
3 minutes. And then they get the floor.
May it please this honorable court. Your Excellencies, the applicant state will now exercise its right to rebuttal. The respondent state has submitted that the situation of Acastus vis-à-vis the United Nations does not amount to UN membership and has quoted the legality of use of force case as support for his argument. But we note that this case is not a valid precedent for the case of Acastus for two fundamental reasons. First, because of the political issues that were dealt with in the case of Yugoslavia, given the ongoing crimes that were taking place in the region. And second, because...
Could I ask how that's relevant, the fact that there were political aspects?
Your Excellencies, because the claim of Yugoslavia to continue the international personality of the Socialist Federal Republic of Yugoslavia was rejected by the international community, according to several scholars, based on these political grounds.
So you're suggesting that the court took a political decision on
No,
the
Your
legality of
Excellency.
use of force?
No, Your Excellency, the court took the decision in the legality of use of force case based on the fact that Yugoslavia had reapplied for UN membership in the year of 2000, and this application was granted, and the court concluded that a state may not be admitted twice to the same organization, and therefore, with the new admittance of Yugoslavia to the United Nations, this meant that prior to November of 2000, Yugoslavia was not a member. This circumstance, Your Excellencies, is not present in this case. Further, the respondent state has also submitted that indigenous populations do not have special ties with their lands, and that the facts in the compromise are not sufficient to support this. But we would like to call to this court's attention paragraph 151 of the Agostini decision before the Inter-American Court of Human Rights. In that decision, the Inter-American Court stated that by the very fact of their existence, indigenous populations have a spiritual link to their land, which goes beyond mere possession or property of these lands, but that must be understood as the fundamental basis of their cultural integrity, their spiritual identity, and their economic survival. Therefore, Your Excellencies, by the mere fact that the Elysians are an indigenous community, they have special ties to the Elysian, and therefore, by permitting the construction of the pipeline, Rubra would be infringing this right. Finally, we must not forget, Your Excellencies, that at the core of today's issue is precisely the subsistence and the culture of the Elysians. And bearing this in mind, we would like to quote Maya community leader and Nobel Peace Prize winner Rigoberta Menchu's words. Your Excellencies, the loss of an indigenous community is a denial of the origins and roots of mankind. May it please the court.
Thank you very much. I give the floor to the defendant, respondent for the rebuttal.
Thank you, Mr. President. Mr. President, Your Excellencies, may it please the court. The applicant has raised two points that serve at rebuttal. First, that we rely upon the legality of the use of force case. We do not rely upon that case for the propositions that the Acastian agent has suggested. We brought up the opinion for the propositions that a temporary member could not appear before the court, as well as for the propositions that it stated with respect to Article 35.2. I apologize if I misspoke, but I do not remember bringing that case up for another proposition. In terms of the indigenous populations argument that the agent from Acastus has made, even if we assume, Your Excellencies, that the Article 27 is implicated here, the relevant consideration is of balancing the relevant rights here. And Article 47 of the ICCPR provides just such a balancing test. It provides, Your Excellencies, that as between the rights of permanent sovereignty and the other rights in the covenant, the right of sovereignty shall prevail. Your Excellencies...
Where do you find that the permanent sovereignty shall prevail?
The specific language, Your Excellency, is not exactly like that. The language says that nothing in the present covenant shall be interpreted to abridge the rights of peoples to fully and freely use their permanent sovereignty. I paraphrase somewhat.
Without respect for minorities or neighboring countries or the environment?
There are certainly limits on sovereignty, Your Excellency. We merely point to the fact that when sovereignty is fully violated, as it is here we submit, or another right in the covenant is fully violated, that sovereignty should trump. There is also further support for this proposition, Your Excellency, in the case...
Excuse me, but why sovereignty would be fully violated in this case? Apparently what is contested is not the fact that you are entitled to make a pipeline, but the line that the pipeline will take. I mean, it would be very easy to move it away from the Elysian fields. Undoubtedly, it will be more costly, but that could be a way to solve the issue.
Very brief reply.
Thank you, Your Excellencies. The compromise provides that there is no other way to build the pipeline. Therefore, if there were another way, the specific words used is that other ways are prohibitively expensive.
So it's not exactly no other way.
Yes, Your Excellency. We do, in closing, submit that since Acastus also has obligations under Article 27, were this court to decide that we have a right to build the pipeline, we would be happy to consult with them and to negotiate in good faith with them to come to a peaceful conclusion. Thank you, Your Excellencies.
Thank you very much. The court will now retire and render its judgment. It's not going to take 6 months, but rather half an hour. And would you please remain in the courtroom? Thank you.
All right.
Please be seated. Just a few introductory words will be very brief because the tension is rising. You can see the temperature, the tension from the temperature here. First of all, I think the court extends its really warmest and most sincere congratulations to both the teams. We have been very much impressed by the level of your performance to come out of a competition which brought almost 100 teams to this Jessup competition. To come out as the two finalists is an achievement in itself. And I think compared to that, it's not really very relevant, at least as far as I'm concerned, who wins. You were both winners in a certain sense, in a very important sense. My two fellow judges will very briefly, or we will give very brief evaluations of your performance, and I ask Judge Sir Michael Wood to start.
Well, I'll be very brief. I mean, just to congratulate both teams for their excellent presentations. I think it's a very demanding problem, and you responded very well to some very demanding questions from my fellow judges and from me. But I'd also like to congratulate all of those who've participated in this, in the earlier rounds of this competition. I really appreciate that it's a huge amount of work that goes into it. I've always had the highest regard for the Jessup moot, ever since I refused to participate in it myself when Professor Parry at Cambridge University tried to persuade me to do so. I obviously thought it would be easier to be a judge. A good number of the lawyers at the Foreign Office have participated in it, and I must say that when we look at CVs, it's something that stands out, the fact that that lawyers have participated in this moot when we're deciding who to interview. And I'm sure that the experience which all of you have gained through this competition will prove invaluable to you in your future careers. So thank you very much indeed. It's been a privilege to judge.
Thank you.
I participated as a student, not in the Jessup, but in a similar international moot competition. I then participated as a coach and then as a judge, but it's the first time that I'm a judge in the Jessup. So the first thing I can say from a comparative point of view is that you did extremely well. You did extremely well, and congratulations to all of you. What I remember from my participation, and I must say more as a student than as a coach, which is a very stressful position, less stressful than judge, is that it is a great experience. not only from a professional point of view, but also from a personal point of view, and see people, to meet people from different countries, different continents, all grouped together. And I'm sure that all of you will keep a fond memory of this week, whatever the result is. You certainly have faced a very hot bench, I would say. I hope that you were happy about that. Again, I remember as a student that I was a bit frustrated with those judges not really asking me any question. I don't think you can complain about that today. So congratulations to all of you, irrespective of the result, and I certainly agree with the Chairman that at the end of the day, the results are important, but not so important compared to the experience that you have lived through this week.
I have already expressed my appreciation. I think we all agreed that the two teams were got very close of each other with regard to just the quality of both the written work and the oral performance. I think the written briefs, the memorials are just about at the same level of quality we found. Let me just make a remark that I, as a non-American who has never done an LLM or any studies in the United States, always find it a bit, let's say, interesting that how this, the way this is handled resembles more a U.S. Court of Appeals way of dealing with a case than an ICJ way. Of course, we are all prima donnas at The Hague and love to be addressed as excellencies, but in front of the court, all is said is Madame President, and the French have a big problem, whether it's Madame la Présidente or Madame le Président, and the Academy, the French Academy of Sciences is in favor of Madame le Président, so okay. And otherwise it says, and members of the court, or sometimes distinguished members of the court, but I'm not going to eradicate that from Jessup. I was yesterday, the university press that you might have seen in the hotel at the basement came to me and said, do you think that somebody might be interested in getting a free copy of the statute of the International Court of Justice, that this is a great idea, can we have two? And so let me just indicate that both of you are going to get, as a sign of our, not just Oxford University presses, but as a sign of the appreciation of the court, each a copy of the statute of the court. Just imagine it's $500, so it's really a very sincere appreciation.
A few additional.
And that now gets me to the moment of truth, I'm afraid. I've always had a hard time deciding which side I found better at The Hague in the actual cases, but that's part of the role, the job description, so we had to arrive at the decision. And our decision is in the sense that the team of Rubria is the winner. May it please the teams, before the big partying and the hugging and kissing begins, just to see that we also had to decide on the best oral performance, and the court has come to the conclusion that Mr. Vincent Levy has been the best oralist in that competition, and our congratulations go to the team and to Mr. Levy. But I think we should also give a strong showing of hand to the team number 2, because you were also great, but we had to decide on a winner. All right.